Good morning, one and all present here today physically and online. I welcome you all to the second day of the second International Research Conference on Insolvency and Bankruptcy, organized jointly by IIM Bangalore and the IBBI. The conference was inaugurated yesterday by our chief guest, Honorable President, National Company Law Tribunal, Sri Ramalingam Sudhakar, and other dignitaries, including Guest of Honor, Honorable British Deputy High Commissioner Mr. Chandru K. Iyer, Special Invitee, Honorable Judge, Appellate Division, Supreme Court of Singapore and Judge, Singapore International Commercial Court, Honorable Justice Kanan Ramesh, Chairperson, Insolvency and Bankruptcy Board of India, Sri Ravi Mittal, Honorable Members of National Company Law Tribunal, Mr. Avinash K. Srivastav and Sri M. K. Dubey, whole-time members IDBI, Sri Sudhakar Shukla and Sri Jayanti Prasad, Professor Rishikesh T. Krishnan, Director IIM Bangalore, Professor Jaydev, Director CCMRM IIM Bangalore, and we also had a very enriching keynote address by Professor Vikrant Vig on the topic Political Economy of Rulemaking and Financial Regulation. I once again welcome you all to the second day of the three-day International Research Conference. Ladies and gentlemen, we will now proceed with the first panel discussion of the conference, which is on the topic Insolvency Resolutions, a special case for SMEs, which is being chaired by Mr. Avinash K. Srivastav, Honorable Member, National Company Law Tribunal. May I invite Mr. Avinash K. Srivastav, Honorable Member, to please come to the dais. May I also invite the other eminent panel members. Ms. Antonia Menzies, Senior Financial Sector Specialist, World Bank Group, she'll be joining us online. May I invite Mr. Hiroshi Kasuya, Baker and McKinsey, Japan. May I invite Mr. B. Sriram, former MD CEO, IDBI Bank Limited. We have another panel member, Mr. Satya Venkata Rao, Deputy Managing Director, SIDBI, who will also be joining us shortly. So before we begin the panel discussion, may I request Mr. Avinash Srivastav, Honorable Member, National Company Law Tribunal, to kindly give the opening remarks for this panel discussion.
Thank you very much, ladies and gentlemen. I would like to make a small presentation by way of my opinion. So the topic of this morning is Insolvency Resolutions, a special case for SMEs. Now, in India, we call them MSMEs, micro, small, and medium enterprises. So now, Government of India has been taking a lot of initiatives to bolster the SME sector. As you would be aware, the MSMEs, they are highly employment intensive, and as of now, they are contributing to about 30% of our GDP. So it is envisaged that they will be contributing another 20% in the next 5 years. So the percentage share of MSMEs in GDP will go up from 30% now to 50% as is envisioned. And they will, from the present employment level of about 110 million, they will go up to another 50 million, which means 160 million. So they're highly employment intensive. So Government of India has been taking a lot of initiatives to boost them up. There is something called Aspirational Districts Program, which was launched in January 2018. What it means is that the most backward districts, the least developed districts of the country, they will be taken up for development, for inclusive growth. And SMEs play a major role there because they help to bridge the regional gaps. Now, because of the success of the ADPs, we have since then moved on to the block development programs. So aspiration blocks program. So now about 500 blocks have been identified this year. In January 2023, an Honorable Finance Minister has made an announcement in a budget speech that we will be taking them up for inclusive growth, and in their growth, SMEs will play a major role. So now some of the issues with the SMEs face are timely payments by large private firms. Honorable Finance Minister has made in a budget speech has made it clear that the large private firms they will not get the tax benefit of expenses in case they have not made the payments to the SME firms. Similarly, Ministry of Corporate Affairs, it has come out with an e-form. In that e-form, all the big companies, if they owe to the SMEs payments which they have not made so far, they are bound to report it on a 6-monthly basis. And that information can be made available to anybody with a view to ensuring that the realization is taken through the facilitation councils in the districts. Then there is this Credit Guarantee Trust Fund. This was created in the times of COVID. In COVID times, the SMEs were severely stressed. So a lot of credit facility was made available to them. That was called the Atmanirbhar Bharat Abhiyan. Atmanirbhar Bharat Abhiyan. They started in 2020, and collateral-free automatic loans were provided to the SMEs. This was by virtue of a trust fund which was created by Government of India. And this year, there is a record budget allocation of 22,000 crore for the SME sector. So, it's not moving. Just move it. Move for it. Your pointer is not working. Perhaps low battery. Is it?
Thank you.
Yes. One important development which Government of India has taken is, which is not, I'm not mentioning it here, but I will just mention it. It is called ODOTA, one district, one product. So this, all the embassies of government we are proposing this. So every district will not be highlighted in terms of your chairman, I belong to, it's chicken work. So a lot of chicken work small. For us in the adjudicating authorities in NCLT. Apart from that, these are enterprises. So we are incorporated. Small company also. Now, what are the IBC from the Insolvency Resolution of the SMEs? Program, it with an amendment to IBC, tax. Pre-tax will keep about 7.8 lakh of the active companies in the country. 7.8 lakh active companies is 60% of the active companies. In the companies, and 7.8 lakhs as MSMEs. Having expected that the benefits of that in the section therefore. SMEs. We application of section 29, you have to be eligible under the section for a company which is being resolved. So, mainly when LLC is going to resolve, you will find it as something so itself. Now, since all, the regulations conference on international laws closely as an expedite recognition proceedings. So, this CMH are mentioned that MSP liquidation. We are going to draft program and it's MSMEs have operational creditors to large debtors. Earlier, an operational creditor was allowed to release a section 9 application against the company. Even though he was that, but it could be more. So it was said amongst the one CLP, amongst that this has the MSMEs to some extent to have to follow for that. Where other MSMEs were doing a section 1 case against a large debt who will not be able to pay their monies. But it's not just 1 crore rupees. 63 million MSMEs. All of that. This is what assets of that company. So once they do that, exercise of spend the money by sourcing the company information. Now, this is something which is very important for us to understand and for the time we have to take up with the banks. Because banks have to understand that when should be confident. We find the assessment that many of these people are suffering because of the lack of security.
ಚೇಂಜ್ ಮಾಡಿದ್ಮೇಲೆ ಆ ಸೆಕೆಂಡ್ಸ್ ಹಿಂದೆ ಇಲ್ಲ ಗೊತ್ತಾಗಲ್ಲ ತೆಗಿ ಅದ್ರ ಬರೋಲ್ಲ.
ನೀವು ಚೇಂಜ್ ಮಾಡಿ ಅಲ್ಲ ಬರ್ತದೆ ಅನ್ನೋದು ಮೈಕ್ ಏನು ಕೊಟ್ಟಿರ್ತೀನಿ ಇದೆ maybe maybe bridge.
So there are some solutions and recommendations. First, to establish insolvency resolution to select class of unincorporated proprietorships. Not to extend to all of them, it's too much. But you can consider a select class, which means the MSME, small and medium unincorporated. That's 3.36 lakhs. And we have to honor the proposal which comes from the companies. Select class. With respect to the proposition concerns and the partnership that we are to implement it. Thank you very much for your attention.
Thank you so much, sir, for a very detailed presentation on the SMEs. Ladies and gentlemen, we now have another presentation by another panel member, Ms. Antonia Menzies, Senior Financial Sector Specialist, World Bank Group. She has kindly consented to join us online. Ma'am, may I please request you to kindly begin with your presentation. Thank you.
Thank you. Can I just check that you're able to hear me?
We can hear you.
You can?
Yes, ma'am.
Okay, thank you so much. Good morning, everyone. I would like to thank IBBI and IIM Bangalore so much for inviting me to this event. And I'm really sorry that I can't be with you in person. My name is Antonia Menezes. I'm a senior financial sector specialist in the World Bank Insolvency team. We're a group that advises governments on insolvency reform. We've worked in over 100 countries, and I specialize in advice to South Asian countries. I'm delighted to see the ongoing reforms in India, and I wish IBBI the best of success in these efforts. If we can turn to the next slide, please. Today, I'll be talking about micro and small enterprise insolvency. In particular, I'll look at what are MSEs, micro and small enterprises, because that's really where the World Bank has focused its work. Why do we care about them? How do we develop specific insolvency regimes to address their financial distress? And what are some other emerging market models? And I was very delighted to see the slides of the opening remarks, because I think a lot of this has already been covered. So hopefully we can go through it quite quickly. If we could go to the first slide, please, just a few back. So the next slide, thanks. So the question is, what are MSMEs? And this really is an issue that in the countries where we are working on legislation and advising governments, we see very clearly that there's no standard definition. Different criteria are used in different countries and even across different industries. So some criteria might be the number of employees, the loan size, turnover. You can see on this table on the right that in China, a small business in one industry might be less than 300 employees, but in Brazil, a small business might be 10 to 49 people. So the size of the enterprise is really a fundamental threshold and policy question when developing an insolvency-specific regime for small businesses. And this is really something that governments need to determine at the outset based on their own socioeconomic climate. Next slide, please. And why do we care about MSMEs? Why do they need a tailored insolvency regime? So this was covered in the opening remarks. MSMEs are the backbone of most economies, particularly in emerging markets and developing economies. They account for the vast majority of businesses, often representing more than 90% of all businesses in the country. They also account for more than 60% of employment worldwide and are really important for job creation. But what we've seen is that access to finance is a key constraint for MSME growth across countries and in all regions of the world. In some countries, especially in fragile countries, the MSME financing gap is estimated at over 40% of GDP. But even in more developed countries, such as in the Eastern European region, the MSME financing gap is still over 20% of GDP. So what this suggests is a huge unmet need across all regions. And of course, what we saw with the COVID pandemic was that these challenges became even more severe as access to credit was seriously curtailed for the smallest and riskiest enterprises. What you see on this slide is World Bank Pulse data. It's a bit old now, from 2020, but what it shows is that during the pandemic, smaller and informal businesses were more severely impacted by the crisis, and not only during the crisis, but also over the course of recovery. Next slide, please. So what are some of the specific challenges for small businesses? Why can't they just use the ordinary insolvency regime? We've seen that generally they have very few incentives to access the insolvency process. They always come to it too late when rescue is almost impossible. that a huge problem we've seen across the globe is creditor passivity, that creditors have no incentive to engage in the process, because for creditors, the cost benefit and advantages of having some relatively small sums of money and having to go through a formal court process is very low. There's just very few incentives for doing that. Often there's very limited information during the insolvency process. For instance, small businesses typically don't file audited financial statements. As I just said, they find it difficult to access finance. There's something that I'll talk about later, a huge overlap between business and personal insolvency laws. And so there's often intermingling of assets between the entrepreneur's business assets and personal assets. And there, as was mentioned in the previous presentation, typically with MSMEs, there are often insufficient assets to fund the insolvency process. Next slide, please. The World Bank's done a lot of work in this area. Some of our reports are here. You can find them on our website. And following this period of research, we published our principles on effective insolvency and creditor debtor regimes. So these are standard setting principles. They're used when assessing countries in formal financial sector assessment programs, often with the IMF. And they're also used as guidance by countries when they're developing legislation. Next slide, please. And so we developed principles on what was best practice guidance for countries to consider when developing specific regimes for MSEs, micro and small enterprises. First of all, the processes should be convenient, inexpensive, and easily accessible. And procedural formality should be limited. So for instance, we encourage the use of electronic voting, minimizing a lot of procedural formalities, minimizing and lessening evidentiary burdens, etc. There should be an easy conversion from simplified proceedings to ordinary proceedings and vice versa. What we found in some countries is that even though it's very appealing to have processes that suit all enterprises, in certain situations, this might not be suitable. The case might be very complex, even though it's an MSE, or it might warrant some kind of conversion to ordinary proceedings for fraud reasons or asset tracing reasons, etc. We still recommend that there should be approval of reorganization plans by a majority of creditors. But in our principles, you'll see that what we also recommend is when creditors fail to cast a vote on the plan because of the creditor passivity problem I mentioned, then that should be deemed approval. We recommend that the management of the business should remain with the debtor, so a debtor in possession model, but that there should be an independent supervisor or trustee or someone to assist where warranted. And the reason for this, it goes back to what I said about how we found that MSEs come to the process too late. We found that if they risk displacement and losing their business because the debtor in possession model is not there, then the likelihood is they'll come to the process even later. And something that was really core to the principles that we spent a lot of time discussing with a number of countries was discharge of good faith natural person entrepreneurs. We still see stigma as a huge problem across the globe. And this is really something that I'll talk about more in a minute. And finally, institutional considerations. All of this needs to be supported by relevant institutions, and these can range from debt counseling institutions to alternative dispute counseling. Thank you. Next slide, please. Sorry, if you could go back. Yeah, next slide. So I'm just going to run through a few country examples because I was asked to address how have other countries addressed this problem. I think the point that I really want to emphasize is that we need to consider personal bankruptcy regimes. As you heard, the bulk of MSEs are sole proprietorships, and this should not be ignored. When you say micro businesses, particularly in common law jurisdictions, you often are meaning sole proprietorships, unincorporated partnerships, and other enterprises that go through the personal bankruptcy regime. The experience that I've seen is that personal bankruptcy frameworks are still very rarely used in practice. And even in India, the fact that the provisions haven't been notified might be something to be considered in the future. If we could just go to the US example. So what we saw with Chapter 7, personal bankruptcy framework in the US. Yeah, that slide. Several studies show a connection between a country's personal insolvency law and entrepreneurship. So a survey of over 20,000 families in the US showed that more entrepreneurs were around in states that had higher asset exemptions. Similarly, another study in the US compared bankruptcy exemptions and found that the probability of starting a business was 25% higher in states with higher exemptions. So there has been increasingly a body of work showing that more forgiving personal bankruptcy regimes have a direct correlation with entrepreneurship levels. The other model, if you could just go back 2 slides maybe, the other model that has been discussed a lot has been the US Small Business Reorganization Act 2019, which introduced a new subchapter 5 of Chapter 11. So you can see it here. Exactly, this is the right slide. So this applies to small business debtors. Under the Act, it's for debtors who have a ceiling below $2,725,625. But in fact, during the pandemic, this threshold was raised to 7.5 million. So debtors who are eligible have to have debts below the ceiling of 7.5 million, although that was a pandemic exception under the CARES Act. The estimate is that 40% of Chapter 11 debtors will qualify for the SBRA. And the objective is to streamline the process by which small business debtors reorganize and rehabilitate their financial affairs. Generally, it applies for debtor in possession. The debtor remains in possession of its business with trustee assistance for certain oversight and monitoring activities, like conducting an assessment of financial viability. The court can confirm a plan even if all classes reject it. And if the court confirms a consensual plan, a sub-5 debtor can receive a discharge. Next slide, please. Singapore introduced a simplified insolvency program under the Insolvency Restructuring and Dissolution Amendment Act 2020, and it provides simpler, faster, and lower cost proceedings for MSMEs, both in restructuring and winding up. So some of the key features are restructuring or liquidation process is completed within 90 days. The simplified debt restructuring program has companies eligible if they have 30 or fewer employees, 50 or fewer creditors, and a maximum liability of $2 million and a maximum annual sales turnover of 10 million. Once the company is accepted into the simplified debt restructuring program, the official receiver appoints a restructuring advisor to help formulate a compromise. And it also provides for simplified winding up, which generally just simplifies requirements. So for instance, there's no need for a creditors meeting and the official receiver is automatically appointed as liquidator. What I think is interesting to consider, and a lot of countries are looking at this issue right now, is remuneration of insolvency practitioners is partially subsidized by the government. And there is a lot of discussion right now about how do you fund these no income, no asset cases in particular. And finally, Australia. In 2021, Australia introduced a small business restructuring law to facilitate a faster and cost-effective restructuring and liquidation process. And so some of the key features are that it has as well a debtor in possession model, allowing companies to retain control. The eligibility requirements are that the debtor cannot exceed 1 million Australian dollars of total liabilities, and that the small businesses work with a restructuring practitioner to develop and propose a plan to creditors that will bind the company, its officers, and certain creditors if accepted. Next slide, please. So just as a concluding comment, I would reiterate First of all, the jury, frankly, is still out about how successful these regimes have been. Although anecdotal evidence in the US is that the SBRA has been very highly effective, and the judges I've talked to speak very highly of it. But we still haven't seen the kind of empirical research that lets us say that, yes, these MSME frameworks have a high impact on saving small businesses. What I do think needs to be considered by jurisdictions generally going forward is the role of personal bankruptcy regimes, particularly in common law countries. And in that context, we would urge countries to consider reducing stigma by focusing on discharge and maybe exempt assets and other features in the personal bankruptcy law that can really help mitigate entrepreneur risk, such as alternatives to bankruptcy. Thank you so much. Please feel free to contact me if you have any questions, and I wish you a very good conference.
Thank you so much, ma'am, for a very insightful and comprehensive presentation. And thank you for joining us online. Thank you, ma'am. Ladies and gentlemen, before the panel discussion, we have another presentation by one of the panel members. May I please request Mr. Hiroshi Kasuya, partner Baker & McKenzie, Japan, to kindly present.
Hello, everyone. First of all, I would like to thank IIMB and IBBI for giving me this great opportunity to present Japanese restructuring and insolvency law for SME. This is my first visit to India, and it's an honor to be here. And I'm very delighted and excited to make this presentation. Okay. As a brief introduction of myself, my name is Hiroshi Kasuya, and a partner of Baker & McKenzie Tokyo office. I'm focusing on cross-border restructuring and insolvency matters. Okay. Here's today's agenda. I'm going to talk about the background of SME in Japan. And then I will talk about overview of restructuring and insolvency laws in Japan and out-of-court workouts for SMEs in Japan. And then I will present some case studies. And lastly, I will a little bit touch upon majority board workouts to be introduced in Japan. Okay. First, I would like to talk about the environments surrounding SMEs in Japan. In Japan, the SMEs represent 99% of total number of companies and employ about 68% of total number of employees. So, as in the other countries, in Japan, the SMEs play a very significant role in Japan's economy. And currently, many SMEs are facing financial difficulties due to the excessive debts incurred in COVID-19 pandemic, and the repayments of the loans started from last year, and also due to the economic conditions such as rising costs and weak Japanese yen. Okay. In order to do such issues, as a measures for vitalization of SMEs, Japanese government published SMEs vitalization package on March 4th last year. This policy consists of first, continuous assistance of liquidity for SMEs, and also provides comprehensive assistance of improvement of profitability, restructuring, and restart of SMEs. In line with this, the SME Revitalization Support Councils, which is a public organization to support restructuring of SMEs, is reorganized and transformed into the new SME Vitalization Council last year. And also, SME restructuring guidelines are introduced last year. I will touch upon these two items later in this presentation. Okay, next, I would like to talk about the overview of restructuring and insolvency laws in Japan. There are two categories. One is the legal proceeding. We have four legal insolvency proceeding. Civil rehabilitation and corporate reorganization, which is a restructuring type insolvency proceeding. And we have also bankruptcy and special liquidation, which are a liquidation type legal proceeding. On the other hand, we have out-of-court workouts system, which is very frequently used for SMEs. Basically, out-of-court workouts is conducted solely based on the agreement between the parties. However, we have certain rules to govern out-of-court workouts. This is a rule-based out-of-court workouts. There are some rule-based out-of-court workouts in Japan, but I would like to focus on this SME Vitalization Council scheme and SME restructuring guidelines. Okay. First, I would like to overview legal proceeding, insolvency proceeding in Japan. As I mentioned, there are four legal insolvency proceeding: civil rehabilitation, corporate reorganization, bankruptcy, and special liquidation. As I mentioned, civil rehabilitation and corporate reorganization is a restructuring type proceeding, and bankruptcy and special liquidation are liquidation type proceeding. In civil rehabilitation proceeding, the debtor's existing management continues to operate the business during the restructuring. And the debtor prepares a rehabilitation plan, which needs to be approved by a creditors meeting and confirmed by the court. On the other hand, in bankruptcy, corporate reorganization proceeding is mostly used for large corporation and not SMEs. And bankruptcy proceeding is a court-supervised proceeding, and bankruptcy trustee is appointed, and the trustees administer the case and liquidate the assets and liabilities of the debtor and distribute the remaining assets to creditors. And the special liquidation process is a liquidation process specifically designed to restructure, to liquidate insolvent companies. So the liquidator basically liquidate the debtors pursuant to a repayment plan, which will be approved by the creditors and confirmed by the court. Okay, this is a brief comparison of bankruptcy and civil rehabilitation proceedings. And as I mentioned, In bankruptcy proceeding, the bankruptcy trustee will administer the case and liquidate the assets and liabilities of the debtors and distribute the remaining assets to the creditors. On the other hand, in civil rehabilitation process, the debtor continues the business even during the process and prepare a rehabilitation plan, which needs to be approved by creditors meeting and confirmed by the court. Okay. Next, I'd like to talk about out-of-court workouts for SMEs in Japan. There are two key features of SMEs restructuring in Japan. One is out-of-court workouts, and another is guidelines. And as for out-of-court workouts, out-of-court workouts is most used for SME in practice. In other words, in Japan, when we restructure the SMEs, the first choice is out-of-court workouts, not the legal insolvency proceeding. Why? Because workouts involve financial institution creditors only, not involving trade creditors, tax creditors, and employees. And this process is totally confidential. It is not disclosed to the public. So the out-of-court workouts process can maintain value of the business without credit insecurity. This is why the out-of-court workouts is used for SMEs. On the other hand, we have another feature, which is the guidelines. You know, as I mentioned, using rule-based out-of-court workout is very common in Japan. And workouts are increasingly governed by guidelines. So I will touch upon the SME restructuring guidelines later in this presentation. Okay. Next, I'd like to talk about methods of restructuring in workouts in Japan. If the financial condition of debtor is not so severe, rescheduling of payments might be necessary, might be sufficient. However, if the financial condition of the debtors is very severe, we need to take a more drastic restructuring method, such as a conversion of debt to equity and conversion of debt to subordinate debt. And debt forgiveness is also available in certain situations, which directly improves the financial condition of the debtors. And also, this is a unique, the scheme in restructuring in Japan. There is a so-called second company scheme. In this scheme, debtor transfer the business to another company, and that debtor is liquidated under the liquidation process. This second company scheme is frequently used in SME restructuring. Okay. This table shows a comparison of rule-based out-of-court workouts process, which is Council's scheme and guidelines. As you can see, these two processes are very similar. However, the SME Council scheme is started since 2008, and so it has about 15 years history. On the other hand, SME guidelines has just introduced in last year. And we can see some differences between two processes. First of all, deadline for resolving insolvency is basically 5 years. So in other words, under this scheme, the debtor needs to resolve the insolvency within 5 years. And also, it should be noted that a certain subsidy is available for all these schemes. And standard timeline is 5 to 9 months for council scheme, and 3 to 6 months for SME guidelines. Okay. I would like to get into the details of the SME council scheme. As I mentioned, SME Vitalization Council is a public organization to support business improvement and business revitalization for SMEs. And interesting things is that SME councils has offices in each of all 47 prefectures in Japan and have consultation desks for SMEs. And also, as I mentioned, this council's scheme is most used restructuring scheme for SMEs. Okay. This chart shows the process of council's scheme. First, a debtor contacts a council established in each prefecture, and the council will support for restructuring plan, for formulating a restructuring plan. And then the debtor will send a request for standstill to financial creators, and then prepare the restructuring plan. The councils examine the plan and review the plan and state some opinion to such plan. And if the restructuring plan is approved by all financial creators, the plan will be approved and implemented. Okay. I would like to explain another out-of-court workout system, SME restructuring guidelines. This is you can see the right hand of this slide. You can see the structure of this scheme. As I mentioned, SME restructuring guidelines is established in March last year by representative of financial and other industries, together with impartial professionals and academics. So these guidelines are not established by the government. This is established by basically the representative of various industries and professionals. There's no legal binding effect, but supported by SMEs and financial institutions. Okay. The key features of this guidelines is that the third party supporting professionals is appointed by the debtors, and they review the restructuring plan from a fair and equitable perspective. By doing so, the restructuring plan should be fair and appropriate and approved by the creditors. Okay, this is a process for guidelines. First, as I mentioned, a debtor appoints a third-party supporting professionals, and then debtor send the request for a standstill to creditors and formulate a restructuring plan. And the third-party professionals review the plan and express their opinion to the creditors. And if all creditors agree to the plan, the plan will be approved and implemented. Okay. I will explain some case studies in Japan. This is a so-called second company scheme, which is frequently used in restructuring for SMEs in Japan. Company A, old corporation, transfers the good business to new corporation, which is called a second corporation, funded by investor. And then the company A, old corporation, repaid the debts to creditors, and then it will be liquidated by a special liquidation process and released from remaining debts. Okay. And next case study relates to the SME guidelines. This is an actual case in Japan, recently occurred in Japan, published by some articles in Japan. In this case, investors acquires the real estate, the collateral from shares from shareholders, and also investor acquired loan claims from banks, and then investor paid banks the price of loan and price of collateral. And as you can see in the timetable in right hand of this slide, it took only several months to complete the restructuring of the data. It's very quick and very cost effective. Okay, finally, I would like to touch upon majority vote out of court workouts in Japan. As I discussed, currently, out of court workouts in Japan requires unanimous consent of all financial creditors. So it is often difficult to obtain consent from all financial creditors. It is a difficulty of the Japanese SMEs facing in their restructuring. However, last year, the Japanese government announced that it is considering introducing a new out-of-court workout rules. Under the new rules, restructuring plan will be binding if a majority vote of creditors is obtained and the plan is confirmed by the court. And this new majority vote workout system is discussed currently, and Japanese government is planning to submit a bill for the new legislation in this year. If this new system is introduced, the out-of-court workout will be very easily conducted, and it's gonna be very helpful to SME restructuring in Japan. Okay, this brings me to the end of my presentation, and thank you for listening to my presentation. Thank you so much.
Thank you so much, sir, for this comprehensive presentation and sharing insights from a different jurisdiction. Ladies and gentlemen, we will now proceed for the panel discussion. And may I please invite Mr. Avinash Srivastav, Honorable Member NCLT, to come to the dais. May I also invite the other eminent panel members. Mr. B. Sriram, former MD and CEO, IDBI Bank Limited. Mr. Hiroshi Kasua, Partner, Baker & McKinsey, Japan. Mr. V. Satya Venkata Rao, Deputy Managing Director, SIDBI. So Mr. Srivastav will be chairing the session and Mr. V. Satya Venkata Rao will be moderating the session. Over to you, sir.
Good morning to the distinguished co-panelists and good morning to all the participants. First of all, I would like to congratulate IIM Bangalore and IBBI for organizing a conference which is having huge relevance at this point of time when the country is progressing and recovering from the COVID effects. In fact, the entire discussions and the presentations which we have seen for the last 1 hour shows the tone and tenor of this conference in trying to understand what should be the best way to move forward when it comes to the pre-packaged insolvency or the insolvency resolution process for the MSMEs in the country. The importance of MSMEs and their contribution to the economy need not be overemphasized and highlighted, as it is well documented and it is well established. But what is important is to find a way to support them in times of distress. In fact, if you look back for the last 20 to 30 years, we have been having numerous kind of deliberations with regard to the corporate debt restructurings and other kind of legislative framework which we had. For the benefit of all the participants, I would like to recall the Sikh Industries Companies Act and thereafter the Debt Recoveries Act, the Securitization Act, and now the Insolvency Bankruptcy Code. What are all these? Are these problems of recovery? Are these the problems of the corporates to pay their debts in time and to revive their business in time? To discuss these issues and to importantly lay down what should be the framework for the future is what these distinguished panelists will be trying to attempt. In fact, this conference is more about learning from other jurisdictions because we have already built one pre-packaged insolvency resolution process, and the presentation by Srivastava ji has shown that the traction is still to gain as far as this is concerned. There could be varied reasons for this slow progress. We will try to analyze this in the coming half an hour and try to see how best we can come to some definitive conclusions as to which is the best way forward to make this insolvency resolution for MSMEs to grow in the real spirit in with which the policymakers, lawmakers, practitioners, etc. are trying to move forward. With this, I would request Sri Srivastava ji to really highlight why the MSME insolvency resolution process is not gaining traction. Are there any other specific steps which we need to take in the present context, or are there reasons by which the MSMEs themselves have inhibitions in trying to use this particular platform? Just hand over to Srivastava ji.
As I mentioned in my presentation, two major reasons which we have discovered why pre-packs have not taken up in a big manner here are as follows. Number one, there is more to be done in the field of advocacy of pre-packs, and extension efforts are needed both by the creditors, the government banks, as well as by the government authorities, be it the MSME ministry, be it the I would say IBBI and oblique MCA. So more of advocacy is perhaps needed in this direction to bring forth the concept of pre-packs before the companies, the MSME companies, the 780,000 companies, which are about 60% of all the active companies in the country, because there's hardly 6 of them who have come forward with pre-packs. The second thing, as I had said, was that those MSME companies which do prepare some pre-packs and approach the banks, the creditors for support, we are aware that this kind of support from the creditors is not forthcoming to the extent to which the policymakers would have desired. So there would be a need to impress upon the creditors also that they should move out to handhold the MSMEs to come up with their plans, their pre-packs, and to present them before the NCLT so that the same are approved and the MSME companies the sick MSME companies are turned around. Now, I'm sure that you all know about pre-packs, but I thought let me just briefly put the thing in its proper perspective. The IBC regime, it envisages a creditor in position or a creditor in control regime. It's a complete change from the earlier regime of debtor in control, which was being done under the Sick Industrial Companies Act, under the insolvency proceedings, under the company law and all that. So with the debtor in control, with the creditor in control, we have found that the promoters, the management of the companies, they are really now out to pay back their loans and to ensure that the companies run solvently and efficiently. Because this fear of the companies, slipping away from their hands was not there before. This IBC has had a salutary effect in that direction. And now people are, the corporates are generally paying back their loans and ensuring that their operations run successfully and solvently. So that is one major step which IBC has achieved. I'm not only talking about the cases which come before us. I'm also talking about the salutary effect of the cases which we have approved, and the cases which therefore have stopped coming before us. Maybe some study can be done by some of the research organizations on this aspect. Those which have stopped coming, which have stopped running into insolvency because of the salutary effect of IBC and the National Company Law Tribunal. The other one, the pre-pack. Now, what the pre-pack is slightly different from the creditor in control model. It is the debtor in control model, as somebody said, DIP, debtor in position model. So the debtor continues to remain in control of the company, but there is a court-appointed trustee, as they call in the other regimes. In India, we call it resolution professionals. So along with the resolution professional, a plan is prepared, a resolution plan is prepared, and the debtor prepares that plan that is then approved by the creditors, and then they bid it out. There is a Swiss challenge mechanism, so anybody else can come forward and put up a better plan. So the debtor is also on his toes to prepare a good plan which will stand and which will meet the creditor's approval, and the creditor also get a good deal out of it. However, it has not really picked up in the manner in which we have wanted it to. And I believe these are the twin reasons: the extension efforts needed by the government machinery, as well as the kind of support which the debtors, with the creditors should come forward with. Thank you.
Thank you for really elucidating the reasons why the traction is not yet there. Now, I would like to move to the regulatory perspective. In fact, the regulators have been very active when it has come to the introduction of the insolvency code, and we have seen so many regulations being framed within no time according to the situations that have developed, and they have paved the way for a nearly successful implementation of the corporate insolvency resolution process for the large corporates. Keeping this background in mind, I would like to request Sriramji to really specify as to what further that the regulators can look at in making this pre-packaged insolvency much more successful than what it is today.
Thank you, Mr. Rao, and thank you to all of you and to IBPF for inviting me here. More than talking as a regulator, I'd rather talk as a practitioner, because I have done almost 40 years in this line of starting from my joining the banking industry in 1981 as SBI, and then at the end of it, now as a part-time member in IBI. We have come a long way, let me tell you, in terms of funding to MSME. Well, in those days, we used to call it SSI and SBF sectors. That if people are still remembering that. And subsequently, it was changed to this. We have come from a way where we were, as field officers, relationship managers to what we call MSMEs. And almost on every Friday, I remember my days as field officer, almost on every Friday, because Saturday used to be the weekly wages for MSMEs. There used to be a huge crowd of people wanting to draw excess and pay these salaries. And that is how challenging it was in those days as well. From there, we have come a long way to now completely disassociate ourselves from MSME in terms of interaction with them on a daily basis, going into digital technology and so on and so forth, which does the not only the underwriting appraisal, but also does the other works that are required for that. Before I have a few suggestions, but before that, just 2-3 comments on the speakers who went earlier. I really appreciate what Honorable Srivastavji said in terms of misusing the process or the definition to try and get gains. I think that is something that we have to have as a challenge. We have done it. The government has an issue with that. The creditors, the financial creditors do have a big issue with that. And in that sense, even out of 6 cases that have come up, if one has misused it, it becomes a bit challenging in terms of promoting a certain way forward in the context of the misuse. So I think that is one big area that we need to work on, and I suppose that will create that comfort and benefit for stakeholders to approach this in a very, because one misuse actually pulls down by significant one. Yeah, 2 misuses, I can say. The second thing which Antonia had said, in terms of reducing stigma. Now, the problem is in stigma, there are 2 things. One is the law can say and do only this much, but it's a society that creates the stigma in many ways. So again, there is a connotation or there is a relationship between law and society in trying to accept that genuine business losses happen because of certain circumstances, and everything cannot be part of a default situation in many ways. We have seen this stigma in a very big way in a large corporate scenario in the CIRP process going through. It has gone significantly away forward in many ways, but we have to attach much more importance to MSME, because these are people who are entrepreneurs of the finest order. They are people who have started with 5,000 rupees, 10,000 rupees, 15,000 rupees and built their small businesses in many ways. So we need to have the laws to protect, and we need to have the society to acknowledge and recognize that stigma is something that is at the bottom of it all. And what Mr. Vashi had said, there are a couple of things that are one of the biggest challenges as creditors that we have in terms of, I think, also discussed that about creditors not coming up with the resolutions and so on, is the distinction between value of business and value of security. Now, the problem is many times in MSME, it's a secured MSME lending, for example. If you have residential property as your collateral, the distinction tends to just disappear in many of our minds. That should we protect the business or should we just create value out of the security and be done with it? Very importantly, I think this is something financial literacy that we have been talking to the bank level as well, is the importance of sustaining a business which creates value for the security doesn't go out anywhere. So that is one thing that we need to understand. And the second issue of MSME specifically is the continuous availability of liquidity. Now, these are the, if I say, this is the first sector to face stress in a situation of normal economic distress. In the value chain of personal till large corporates, the MSMEs are the first one to face distress, and that is where we get the signals whether the economy is doing well or not in terms of trying to just gauge the sort of activity in the MSME market. And therefore, I think yesterday somebody was talking about imminent distress. An imminent distress point, which is driven by the pre-pack that has been done, is largely very important for this sector, in the sense that if you really have a pulse of imminent distress rather than distress as the whole, you will find that things can be addressed much more easily and better. One of the things that I do advocate with banks as well is today you will find that we talked yesterday about artificial intelligence and the sort. in terms of underwriting, in terms of sourcing, in terms of giving credit, there's a lot of underwriting which happens. But in terms of figuring out once the account has become imminent distress or in imminent distress, very easy for banks to figure out because the cash in the account tends to slowly go away in many ways. And therefore, you know that imminent distress is there in the end. Today with GST and all, we are able to find out all that. One of the suggestions that probably could be looked at by banks for pre-pack is to find through artificial intelligence the appropriate method or appropriate requirement of credit for the institution for the MSME to survive, and therefore run a resolution or run a restructuring to suit that and try and put it as a sort of model. So a model underwriting process for MSME in distress, I think that is something that probably will help in figuring out what we can do better. There are a few other or maybe I can come back later. You can just go ahead, I suppose.
Am I audible, Anthony? Yeah. See, in fact, when it comes to India, we are a completely different country, as diverse as it can be, and the diversity extends to its business operations also. So the models which you have shown in your presentation are worthy of emulation as far as India is concerned, provided they are suitable to our domestic conditions. One thing which I would like to know from you is this code-based supervision really required when there is a kind of agreement between the creditors and debtors? Because some of the models that we have discussed, there are role-based kind of settlements, etc., which are in place. So do you suggest similar models for the Indian system, keeping the Indian diversity and the Indian business models that we have?
Thank you. I hope I understood the question, a very interesting question. So first of all, the World Bank principles that I showed you in my presentation, these are just guidance. We completely understand that countries need to be able to adapt models to suit their socioeconomic needs. And models that might be adopted by a lot of other countries might not be suitable for one specific country. So that really is something to bear in mind. That said, the principles that we have set out for MSE insolvency are the principles that we believe, after a lot of research, both empirical and academic, is that these are the main concerns that have prevented small businesses from being either restructured or liquidated effectively. I would say that I was very interested to hear about the workout models in Japan, and this is a new area that is having a lot of traction right now in other countries. So in Europe, I'm sure all of you know, with the European Directive, the Second Chance Directive on prevention, a lot of models have been put in place in Europe trying to facilitate workouts at a very early stage before the business is bankrupt. And I think that is a model that is appealing for a lot of reasons, including for the debtor. They don't feel like they're in an insolvency process. A lot of the issues around stigma have been mitigated with those procedures. And I think that might be something that India might find very interesting. But in terms of some of the core features, so for instance, in the IBC, where you have creditor control model versus debtor and possession model, I think those are decisions that have to be made at a policy level, depending on the needs of the country and what works effectively. Hope that answers the question.
Yeah. Thank you, ma'am. Thank you. And taking the discussion forward on the international perspective, we would like to be highlighted as to the efficacy of debt counseling.
I'll join you.
Yeah, I would like to get the views understood on debt counseling and the financial kind of education that is required to the corporates before they really take up the insolvency in a very sacred manner, because this is not something that we should take it as a taboo. Just like an individual realizes that there are health problems and he requires medical assistance, similar will be the situation when a corporate, big or small, faces some distress. How do we really make them educated about the debt counseling? Are there any specific programs in your country, Mr.
Thank you. First of all, in Japan, there are no debt counseling and education requirements before entering into the formal insolvency proceeding. However, as I discussed in my presentation, the SME councils, which is a public organization, has many offices in each town in Japan, and so basically the SME councils in Japan is safe haven of the SME. So the SME easily consult with councils and discuss about the restructuring of SMEs. And so this, system is very helpful for SMEs to understand the restructuring system and insolvency law. So I like to say that such kind of consultation system is very useful to educate SMEs in terms of the restructuring and insolvency law. Yeah. Thank you.
I'll just step in for a moment in this. For quite some time, is it audible? For quite some time, the issue of micro small industries has been on the forefront of NCLT's adjudication, and it was also flagged by the Honorable Finance Minister and the government. We have had several discussions with IBBI on that issue. As we were on the program, I was also talking to the chairman of IBBI. There are two issues, apart from what my brother Avinash has presented. From World Bank side, Antonia was able to point out there are two models of Singapore and Australia. Our friend from Japan was giving some pre-litigation stage process. Now, the point in which we are now debating here in this second research program is this. If you look at the Indian model, as was rightly pointed out, the diversity of Indian micro small industries is oriented in different cultures, languages, states. Their attitude to finance and insolvency differs from state to state in India. While the concept of financing and repayment and debt and default in Gujarat, Ahmedabad, Punjab, and other Delhi will be totally different from Maharashtra, Tamil Nadu, or even Kerala. This is different again in Hyderabad, in Andhra Pradesh. The mindset of people differs. So we have to tailor make programs for SMEs, micro small industries. This is what I was thinking about, an outreach program, so as to enable these people to come out if they are not able to find a reconciliation with the financial creditors. Therefore, as I said yesterday, there may be one more stakeholder who has to come into this, and there may be the Ministry of Micro Small Industries also. If you take the Japan model, as my friend was saying, there is a procedure which comes before they come to litigation, and that could also be solved. So we need those government to participate in a process where MSMEs are brought into a particular table with the guidance of Federation of Industries or Micro Industries, Small Industries Federation, and a code can be created there so that they can work out their method of resolution before coming to an adjudicatory process, which is the second stage. I think, as Antonia was mentioning, the Japanese model could be examined in consonance with Indian types. And that is where the research of people from IIM becomes very relevant. You have to take that and give us some positive solutions to that. The second one was, Antonia was referring to the Singapore model and Australian model, which I also feel it is correct. If the first stage of resolution does not happen with the council, what the Japanese method called council, which we can have a different name, nomenclature, is that it comes to an adjudicative process. For that, my thought process is simplification. Yesterday, Professor Vikram, am I correct? Vikrant was talking about simplification of process. If a particular SME wants to initiate a process through an alternative mechanism like a council or a forum and doesn't get the proper response from the financial creditors, which may be single or multiple, then he can make an application to the tribunal to initiate a process. But that process should not be cumbersome. It should be, this is where I say artificial intelligence comes. That one pager or two pager application will be just received and all the stakeholders will be brought to a table and they should be asked to come with a resolution plan. It should be so simplified that it does not take a laborious, long-drawn process of adjudication. This is where we need that artificial intelligence, and that is why we need researchers like you. The third one is SMEs are, as were defined, in countries like South America, in India, in Africa, are small enterprises mostly by individual entrepreneurs or for women. And there may be one or maybe at maximum two financial creditors. So it doesn't need a large number of people to be brought around. The only thing is we'll have to create a platform for them to come with a solution. Thirdly, in SMEs, the question of financial creditors getting control is absolutely, I don't think it will work because nobody wants to take it for, as you said, economic reasons, but also it is driven by the knowledge and the capacity of that promoter. It's a lady. For example, you are creating a Bandhani silk sari enterprise and you fail to COVID. Which financial creditor is going to take that? Only you can do it. You can turn around and come back. But what method or incentive will give to them is for the regulators, the government to think and come with a solution, whether the debt will be formed as an equity or it will be shown in takeover. The other model which was taken from Japan is that the second sale of the company. We are also having something like that. It's called a plan, which is given by a third party and it is executed. So these are all various methods, but it should be tailor-made, particularly for India. There are varieties and innumerable permutation combinations of SMEs. It's just not one. There is no one fit solution for SME problems. So there has to be a collective and proper research done to find out what are all the categories. Like my brother Avinash was saying, 63 million, right? Yes. So that has to be subdivided by the MSME industry because that department should collect and give. See, for example, people who may be doing in parts, small parts supplying to a bigger company. There may be something to do with soap manufacturing and marketing through big corporates like ITC. Because your natural products now come, people make it at home and they sell it through the platform of multinationals or big companies. So each one needs a different set of factory. So keeping that in mind, maybe the best practices which are suggested in Europe, in Singapore, in Australia, in Japan, or even South America. So we should come out with some solution which will be tailor-made for India. We can't give solutions to others, but we have a big problem in SMEs. The more important thing is people like Mr. Sriram, who know the root at the ground level. They should be the persons who should be giving ideas how to give that outreach to these people, because they are not coming forward. So they are coy, reserved. So we have to project ourselves and bring them into the fold. And this is where we need to get the best minds. Thank you.
Thank you for those wonderful insights, sir. In fact, the entire conference, I believe, will deliberate on these kind of things and come with definite conclusions as to what could be the best practices that the Indian system can adapt. In fact, this session, what we had is only the initial round. I'm sure that the successive sessions will lead to furthermore depths of understanding, and we will definitely be benefited by this 3-day conference. I individually thank each of these participants in Congress today for enlightening the participants with their deep and incisive kind of thoughts, which I believe will be taken forward in the next sessions. I thank individually each one of you. Due to paucity of time, we could not deliberate more. Thank you very much.
Thank you so much, sir. Thank you all the panel members for this insightful panel discussion, and thank you, Sudhakar, sir, for your sharing your insights. Thank you, Ms. Antonia, for joining this online. Ladies and gentlemen, we will now proceed for the memento ceremony. May I please request Professor Jaydev to kindly present a memento to Honorable Member Mr. Avinash Srivastav. May I please request Mr. Santosh Shukla, Executive Director, IBBI, to present a memento to Mr. B. Sriram, former MD and CEO, IDBI Bank. May I please request Mr. Amit Pradhan, Executive Director, IBBI, to present a memento to Mr. Hiroshi Kasua, Partner, Baker and McKenzie, Japan. May I please request Mr. Sandeep Garg, Executive Director, IBBI, to present a memento to Mr. V. Satya Venkata Rao, Deputy Managing Director, SIDBI. And thank you so much, Ms. Antonia Menzies, for joining us online. Thank you so much, ma'am. So, ladies and gentlemen, we will be having 4 parallel sessions on the presentations, which will be made by the researchers, which will be in the separate seminar halls. So, you need to move to block N, and the hall numbers would be N001, N103, N201, and N203. So, we are a little short of time, and we were supposed to begin the sessions from 11:15 a.m. So, the tea break will be a little short. And for tea break, you need to proceed to N block only. It will be served outside conference hall N001. And yeah. And please also note that post these sessions, we will break for lunch at 1:30 p.m. That will be served at MDC booths. And we will resume with another set of parallel sessions from 2:30 p.m. onwards. So I may please request to join us for the tea break and thereafter for the presentation sessions. And may I please request the volunteers to kindly guide the participants to N block and to the seminar halls. Thank you. हेलो अंजलि कमिट प्रधान सर निकल गए उनको दे दो यार देखो N001 के बाहर भी नहीं